Hello guys, welcome to another class of the Nigerian legal method. In the last legal method class we discussed theories of law. Things have just gotten better, for in this class we will be discussing the classifications of law. You just don't want to miss any of it. Do not forget to hit that notification bell, like and subscribe to the channel. Generally, laws can be classified into public and private law, civil and criminal law, substantive and procedural law, municipal and international law, written and unwritten law, common law and equity, conflict of laws or private international law, primary and secondary law. Public and private law. Public law is concerned with the protection of the state and its organs. It regulates the relationship between the state and the citizens. Examples of public law include constitutional law, administrative law, criminal law, and international law, among others. Private law, on the other hand, governs the relationship between people. Individuals. It deals with the protection of individual rights and duties. Examples include law of contract, torts, family law and succession, commercial law, and banking, among others. Civil and criminal law. Civil law is the law that defines the rights and duties of a person to another person. It entails a system whereby an individual who is injured by a wrongful act of another person can be compensated for the damage which he has suffered. Examples are contracts, torts, land and family laws. Civil wrong leads to recovery of money or enforcement of right but not punishment. Criminal law, on the other hand, attempts to protect the interests of the public, generally by punishing certain conduct which is deemed to be harmful to the society. Punishment is imposed in form of imprisonment or fine, or both, to the offender. Crimes may be serious, such as murder, rape, among others. It can be lesser offenses, such as minor traffic violations, minor assault, which may be tried summarily. To be successful in a criminal trial, the prosecution has to prove its case beyond reasonable doubt. But in the civil wrong, the plaintiff need only to prove its case beyond the balance of probabilities. The law demands a higher standard of proof in a criminal case so as to protect the accused person from the mighty power of the state and to avoid the danger of being convicted wrongfully. There may be some overlap in both systems of law. For example, assault, false imprisonment, and defamation are both torts and crimes. Similarly, if A steals B's money, A will be guilty of stealing if convicted, and in the same vein be liable to B for tort of conversion, which is a civil wrong. Substantive and procedural law. Substantive law is the body of rules or legal rules. It defines a code of conduct and prescribes a penalty for the violation of that code. A breach or violation of substantive law may result in a remedy or punishment, which may be in form of a compensation, fine, term of imprisonment, and so on. It covers sub-subjects as law of contract, tort, criminal law, and constitutional law that involve the statement of rights, duties, and liabilities of individuals. Procedural law. Procedural law, on the other hand, concerns the approaches of proceedings to enforce a certain right or duties and how the litigation or prosecution is conducted. It deals with how the substantive law can be enforced in the court. It provides the method and processes required to initiate an action in court, mode of proof, the manner of prosecution, including the manner of giving judgment and enforcement. Municipal and international law. Municipal laws may be national, domestic, or local laws, which entails the internal law of a particular country. It embodies all the laws of a country that governs the relationship between the individuals and between the individual and the state. On the other hand, international law regulates the relationship of sovereign nations and international organizations. It is the rules developed from customs, practices, bilateral and multilateral agreements which governs the conduct of nations and international organizations and their relationship with persons, whether natural or juristic. Important sources of international law include treaties, international customs, general principles of law recognized by civilized nations, including judicial decisions and teachings of the most highly qualified publicists of the various nations. Written and unwritten law. Written law is a rule that has been formally enacted into a legislation or statute by the legislature. Such laws are debated and scrutinized through various stages before they become valid laws. Written laws are usually found in a document and can be said to be a combination of norms in one or more documents. They may be called statutes, code, acts, decrees, edicts, laws, or ordinances. The Nigerian Constitution is a written law. On the other side, unwritten laws may mean any rule or principle that is not written down at all, such as the customary laws and conventions, but it could mean unenacted rule in form of case law. British Constitution is an example of unwritten law. common law and equity. Common law was developed by the King's Bench, the Court of Common Pleas, and the Court of Exchequer. The history of common law was traceable to the period immediately after the Norman Conquest of 1066 AD. Common law grew from the custom common to the people of England and Wales. In practice, common law is very strict, formal, and full of legalism. The rule seemed to be that a plaintiff has no cause of action unless a claimant came within the scope of an existing writ. If not, he would be left without any remedy. Even when he gets a writ to fit his claim, he may not be able to get an effective remedy at common law. Given the obvious injustice as common law, plaintiffs who could not get remedy started sending petitions to the king to use his prerogative to do justice. In view of the seeming injustice under the common law, equity was introduced to ameliorate this in the form of decree by the Court of Chancery. Equity means fairness, just or natural justice, morally right and good. Both the common law and equity were applied side by side under the English law. But the joint administration of common law and principle of equity did not resolve the argument, as there was this issue of which of the two branches of law is superior and should prevail in a conflict. However, sections 36 to 44 of the Judicature Act settled the problem by providing that where there is a conflict between the rule of common law and doctrine of equity, the doctrine of equity will prevail. The provision of this statute had remained part of Nigerian law. Conflict of laws or private international laws. Private international law is otherwise regarded as conflict of laws. This is the law which regulates relationship between two or more persons living in different countries. It regulates their rights and duties. An example in reality is the international business involving persons in different countries. Where there is a dispute involving the right and obligation of the parties in international commerce, the conflict of law comes in to especially determine the following issues relating to jurisdiction: in which country should the case be prosecuted? Law: which law should apply? Enforcement of the foreign judgment: how should the judgment be enforced? If, for example, a Nigerian and a British citizen are in a business conflict, these laws will answer the question how the judgment will be enforced, what law will apply, and where the case will take place. Primary and secondary laws. Primary laws are otherwise known as parent laws. These are laws made by the primary lawmaking bodies of the legislature. Examples of primary laws are Act of Parliament, such as Laws of the Federation of Nigeria 2004. Secondary laws, commonly regarded as subsidiary or delegated legislations, are laws made by bodies other than the primary lawmaking bodies. Examples are rules, orders, bylaws, and regulations. For example, companies make bylaws to regulate their affairs. The Chief Justice of Nigeria makes rules and regulations for the practice of court in Nigeria. There you have it, guys, all the classifications of law. Go through them, comprehend them, like the video, subscribe to the channel, share to your mates, sit tight and anticipate my next video. Thank you.